Hey, Brian Parker again. CollectionStopperMembership.com is our new headline. It's a great membership site for everyone to go to, lawyers or real people. And I'm eventually going to make it your one-stop shop for everything you need from the mind of Brian Parker as far as collection defense goes. That part is sane. Anyway, so today is by popular demand. I mean that because a number of people actually have been saying, where's your JeffCap or Jefferson Capital Systems LLC video? And they are not usually on my radar of late, but then suddenly they are. So I guess people contacting me from other states as maybe they bought a huge portfolio of debt. And today's examination of JeffCap, we'll just call him JeffCap, is regarding a new and growing phenomenon out in the debt world of AI online loans. So very briefly, and this goes to my securitization videos, a bunch of investors get together, they create a fund, a securitized debt process, and they give a bunch of money to, it's not a phony bank, but every deposition I'm in or any interactions with collection attorneys, they all say this particular bank, it's called Cross River Bank, is really just a placeholder for the real entity behind things. And we'll get into that why soon. But this securitized fund has a bunch of bondholders that fund the personal loan business that, again, is growing in this AI model where you're really not sure who you're dealing with, but it's an online presence. What happens is when there is a default, that's where the fund for people like me and educated people like you can have, because debt buyers are buying a lot of this defaulted personal online loans. And when it is securitized, so you and I get a personal loan, we have what's called the originator. In this case today, Cross River Bank is the originator or the original creditor or lender, or it'll be a web bank or prestige funding or something like that. But there's really a company behind it who is at first identified as a servicer. And when there's a default, supposedly the servicer receives the debt by assignment. However, the thing is owned by several what's called investors. If you looked at a previous video I did with UHG, I pointed to right in the bill of sale, it talks about investors. Those are bondholders or secure trusts, but they all have ownership. So therefore, there must be a bill of sale to them or an assignment or a transfer document. And then if there's a default, and in this case, Cross River Bank wants to sell the debt to a debt buyer, in this case, JeffCap, there must be an assignment out of the secure trust back to the originator for the originator to have truly sold the debt to, in this case, JeffCap or any debt buyer. So anytime you see like a Cross River Bank loan or anything prestige, or Upstart Network, that type of stuff, it's usually without assignments from the people that funded the debt, owned the debt in the securitized trust, and then supposedly kicked it out when it was defaulted. And their pooling and service agreement, which is securitization videos of another time, say that that debt's supposed to be kicked out and given back to the originator. I've never seen that. But this AI funding is causing real problems, but a big benefit for anybody being sued on the debt, because there's no assignments to all these investors, and then all the investors in securitized trust back to the originator to then sell the portfolio. But I think I'm the only one that's actually going in hard on this. You are now. And today's case is JeffCap versus my client. It's a Cross River Bank debt that JeffCap alleges they purchased, and not even from Cross River Bank. They're purchasing purchasing from, in this case, they claim a company called Affirm Inc., whoever that is. And what I'll do is first I'll put up an example of the lawsuit, the way I counsel others to look at a lawsuit, which is I tear the lawsuit apart, and then I do my true, false, true, false, true, false. Rarely is it true. There may be some ambiguous stuff. But so here's an example of this particular case we're looking at today, a client of mine, Shazam. And you can see how I've written true, false, true, false. And that's the first page. Just put up the second page, Shazam. And again, true, false, mostly false. And you can see circled is that this, while it's probably I know the guy personally, actually, while it's the debt collector that's putting this on there, this is communication from a debt collector, any attempt to collect a debt, yada, yada. They just made that a debt collection initial contact. And we've talked about under 1692G how they have 5 business days now to contact my client with their validation rights. Ain't going to happen. The attorney here actually works for Jeff Cap. So there's a whole mixture there. So is he representing the creditor? Is he being a debt collector? It's a mess, which is good for you. It's a brick in the wall, as they say. So they allege in their lawsuit at paragraph 4 that they're successor in interest to Cross River Bank. Yet there's no specific, they say look at Exhibit A. So let's put up Exhibit A, Shazam. And Exhibit A has no date other than the date of when apparently Affirm and Jeff Cap got together. Keep in mind, this is December 2022, and Cross River is not mentioned in this bill of sale. Where's the bill of sale from Cross River to Affirm? There's going to be later on, or earlier on, a certificate of title sort of saying that, but let's stick to, I'll try not to go off the rails like I normally do. But there's no document showing the specific debt of Cross River to Jeff Cap, as they are claiming in their paragraph 4. Again, let's put up the lawsuit at page 1, Shazam. And you can see paragraph 4 there says, the plaintiff Jefferson Capital is a successor in interest to Cross River Bank. There's no document saying that. And they say go to A, which is again, bill of sale, Shazam. And that's from Affirm to Jeff Cap, but not Cross River. So next, we look at their certificate of title, which is signed April 2023. So the first document appears to be December of 2022. The second document is April of 2023, and that shows Cross River assigning the debt to Affirm Inc. That would be cool if those dates were reversed, but how is Cross River sending something to Affirm in April of 2023 when clearly Affirm has already given the debt, I guess, Exhibit A that they claim in paragraph 4, to Jeff Cap 5 months earlier. So that ain't true. There's a chronological problem there. Cross River's not doing anything really. They got nothing to give, or they do, but then Affirm has nothing to give. So it's a broken chain of title. Again, look at the fancy words, certificate of title. They could have just said bill of sale or title. Certificate means, oh, a cert. It must be real. There's definitely reasons why they do that. And it's to add a look of authenticity. As later on when we look at their account stated affidavit, I'm going to just read the words here and you'll get what I'm saying. They believe if they fill it with legal sounding words that denote authenticity, then it must be real. But there is nothing attached to the lawsuit showing any transfer or assignment of this loan or debt from Cross River to Affirm previous to the bill of sale, which JFCAP is telling us to look at it, paragraph 4. Anyway, as I said earlier in the video, all these debts are securitized. That means somebody assigned and what's called the originator, which is also another word for lender. It's only called an originator, the lender, when there is a securitized situation. So when you see the word originator, that's your key right there. There's a securitization because it's called the original creditor. But the originator of the debt is language, lexicon, the type of stuff that's in a securitized situation. And this debt, that's the whole business model of these Cross River Bank loans. It's totally securitized. A bunch of investors have it. So now they have ownership. To receive it, they had to get an assignment, and to send it to somebody, they have to assign it to whoever, like a firm or back to a Cross River, which it should be going to Cross River before Cross River sells to a firm, before a firm sells to JFCAP. None of that is here. You need those assignments attached to the lawsuit to have a perfected chain of title. So all I just told you will be encapsulated in the most important document I've preached about in these collection defenses to lawsuits. And those are, hello? Counter affidavit. So that stuff I just showed you and talked about goes into your counter affidavit. They have filed what's called an account stated statute lawsuit. See all my videos on just that. Killer affidavits, the ASS counter affidavit. All the videos are all on my membership website for you. So they have filed an affidavit. So this is an account stated collection lawsuit, which most of them are. So let's take a look at their affidavit that they're using against my client. Shazam. And then we look at that and we noticed very importantly, and I'm reading it, it's up on your screen, that I'll just read some of it. The duties including reviewing the file, this is the affiant talking, documents and information supporting this affidavit. Said account is in favor of Jefferson Capital. Notice nobody said anything about anything being assigned to JFCAP, and showing a principal balance within their knowledge, just, true, and correct, that is justly and truly due and unpaid, that all just and lawful offsets, credits, discounts, payments have been allowed, and the said amount, nobody talks like that, is due after said allowance and exclusive of all set-offs and just grounds of defense. If you know what that means, I do, but I have to read it a couple of times. But if something had been sold from Cross River to a firm to JFCAP, shouldn't it be in your affidavit account? It should affidavit of account of JFCAP on the screen, Shazam. There is nothing here saying how Jefferson Capital got the debt. Why? That would be number one. Yeah, I got it from Bob. I got it from a firm. I got it from Cross River. That's an affidavit of account stated. Before you say anything else, this is how we obtained this debt. Nothing. That's because it's a fill in the blanks, one size fits all affidavit. So read the content of every affidavit you get. Read and learn about who signed the affidavit. Just go online, look up that person's name. You'll be surprised what you'll find. Look up the notary. Check out the notary that said, yep, he signed right in front of me. That'll surprise you. You can look at the county that they're claiming they signed it in. I've done so far as gone as Facebook. I signed it on April 23rd. And you can see the person's Facebook listing saying, hey, I'm in Aruba. I mean, that's really me going deep. It depends on the case. But that stuff happens. So Google the person's name, the affiant. That's the person that's saying he has personal knowledge. And even the notary. See if she's really still carrying her license to be a notary. I've had cases where they never did. or their LinkedIn page says they're in Virginia when this is signed here in Colorado. Why that is part of a Michigan lawsuit. You got me. Oh, that's where Jeff Cap is located. Anyway, you've got to say in your counter affidavit everything it has talked about that you found when you tore apart the lawsuit and you took a good look at their exhibits. Because under most state laws, you must have a rebuttal. If you don't, it is prima facie evidence that you lose if you don't respond. So you have to do a great affidavit. Let's put my affidavit in this case on the screen. Page 1, Shazam. Just take a look at that. Look at how I break everything down. Now look at page 2 of my counter affidavit, Shazam. You can see I'm pretty clear. My client doesn't owe this debt. Now, let's put up their affidavit again from Jeff Cap. Shazam. See the difference? The court has to make a choice. He or she from the bench can't even understand without several readings. What are they saying? But number one, they're not saying anything or how they obtain the debt. Whereas if you look at my client's affidavit, break it down, why they're wrong, why it's in dispute, why he doesn't owe the debt, and why they don't own it. So you have to, with Jeff Cap, who is a company that does not appear to take much care, as none of them really do, but it's very apparent with Jeff Cap, they don't take much care into matching up their pleadings with their exhibits and showing any proof. If you're doing I've had this in other cases I've counseled you on. If you are doing an affidavit for your company in pursuit of somebody, let's say you're a debt buyer affiant, wouldn't you take greater care and be more specific? It's just a one-size-fits-all, saying nothing. None of this stuff makes any sense, because the mantra that I feed you all the time is use their documents against you. And they tee you up. They give you these beautiful layups, which you incorporate into your counter affidavit, and then you just blow their case away. This case will get settled within days. I just sent everything to the other attorney who I know personally and said, come on, you got to take care of this. You serious? You guys still doing this? And they send out hundreds of thousands of these lawsuits, so they don't take care. They send out hundreds of thousands of those affidavits, those accounts stated, that's got to fit in other states, in other counties. So they have a business need to shape it to be very general. And that's why they put the flowery legal words, so they think makes up for the lack of substance. It's the old flash over substance approach, which they all take, because had they taken the time to do this properly, their whole business model would collapse. Their business would collapse. They pump out hundreds of thousands of these because of the margins are so small. So they don't start with any good proof and they don't end with it, but you use that for you to end a case against Jeff Cap. In this bundle, there will be one video for you with tons of documents, counter affidavits, my answer in this case, my answer in other cases, counter affidavits from other cases, debt notices, and I'll also put in this membership bundle discovery request. The thing with Jeff Cap is it never goes more than a couple of months. That's the longest I've gone with one of these. I guess they would be pragmatic versus don't have any stuff attached to the lawsuit, and why spend money defending this crazy guy against this crazy guy. So I'll settle Jeff Cap cases very quickly. If you have a Jeff Cap case, that's probably going to happen for you too. If you choose, I'm not telling you how to live your life or your law. If you choose to use these templates, they're very valuable in just pointing out to the court what a bunch of crap this is. As this goes on, as this AI online banking platform proliferates, it's going to be bad for debt collectors and debt buyers because they will never get the greater burden now. There has to be more assignments sold with this portfolio of debts that's paid for pennies on the dollar. So previously, we were operating on our assignment theories, which are totally cool. They just don't have them. Now with this personal on loan AI funding approach, it's going to get worse for debt buyers and debt collectors just to prove something that wasn't there in the first place. Now they've got like extra burdens of proving the securitization investors have given something. It doesn't even make it to their own affidavit. So I'm going on and on. I've been told I got to slow it down a bit, but speed it up. Use your counter affidavit. Use my counter affidavit videos. You know what I'll do? I'll throw in a counter affidavit video to this video and make it a bundle for you so it's cheaper and you get more stuff, and add all those documents like I said. And I hope this is valuable to you, and go get them. Brian Parker out. Thank you.